In a recent session before the National Assembly, the Standing Committee on Human Rights and Constitutional Matters, headed by Honorable Mahdi Cisse, submitted its report on the Interpretation Amendment Bill 2023, which seeks to amend the Interpretation Act to strengthen the legislature's role in scrutinizing subsidiary legislation. The bill aims to grant the National Assembly explicit authority to review delegated law-making powers, fostering accountability in the executive's exercise of these powers. According to Standing Order 69, the committee's mandate includes listing witnesses, recording opinions on each clause of the bill, and presenting a comprehensive report that summarizes evidence and recommendations. According to the committee, during its review, they engage in extensive consultations with stakeholders, examined position papers, and held validation meetings to refine its findings. The committee says its members have meticulously analyzed the bill clause by clause with a focus on the importance of ensuring that the bill aligns with the 1997 Constitution of the Gambia and other existing laws.
The committee relied on testimonies of witnesses to review the bill, clause by clause, and taking due notice of any input aimed at adding value to the content of the bill. Cross-references were also made to ensure that the content of the bill was brought in conformity with the 1997 Constitution of the Republic of the Gambia and other laws.
In its findings, the committee expressed support for the bill's objectives, but raised significant concerns regarding specific amendments, particularly Clause 11A. The committee recommended that these clauses not be included in the bill, citing several justifications. The proposed changes could undermine the principle of delegated authority, as the Assembly has already entrusted regulatory powers to ministers who are better equipped to handle complex technical matters. The amendments could overload the National Assembly, potentially leading to delays in legislative functions due to a lack of specialized expertise among its members.
The opinion of the committee on the object and reason. It is proposed that the objects and reasons as presented by the mover during the second reading be adopted to stand as part of the bill in the consideration stage. The short title. The committee proposed that this section not to stand as part of the bill as proposed. The amendment of clause 11A. The committee proposed that this section does not stand part of the bill as proposed with the following justifications. 1. The proposed changes could undermine the principles of delegated authority, as the Assembly already in the primary legislation delegates specific regulatory powers to ministers. Further, this delegation is based on the understanding that ministers often advised by experts, civil servants are better positioned to address the complex and technical matters.
On accountability issues, the Standing Committee on Human Rights of the Assembly believed that shifting regulatory rules to the National Assembly may blur lines of accountability and invite constitutional challenges, and could also hinder ministers' ability to respond quickly to emerging issues, defeating the purpose of timely governance. The Standing Committee on Human Rights and Constitutional Matters ultimately recommended maintaining the current framework where subsidiary legislation is regulated by the executive with judicial review as necessary.
The Assembly bypasses the minister's authority to regulate. It undermines the primary legislation intent, creating confusion around the separation of powers and potentially setting a precedent that weakens established legal frameworks. Honorable Speaker, the proposed changes would put a strain on the Assembly, and this could potentially lead to delays in legislative functions due to lack of specialized expertise which the ministers and their departments have on the implementation and regulation of the primary legislation. 3. The accountability issue may arise if the National Assembly assumes the regulatory rules intended for ministers.
The report also included positions from the General Legal Counsel and the Ministry of Justice, both of which opposed the proposed amendments. According to the report, the General Legal Counsel argued that the current system effectively delegates regulatory powers to ministers who possesses the necessary expertise, while the Minister of Justice highlighted that these may overburden the National Assembly amid existing legislative backlogs. Following the submission of the report by the Standing Committee on Human Rights and Constitutional Matters for consideration and adoption by the Assembly, several lawmakers weighed on the implications of the proposed amendments.
Really well thought, and it's also a legal job. So therefore, Honorable Speaker, I think we are in safe hands. Haven't passed legislation here. We also now allow for the smooth operation or for the smooth operationalization of the legislation, the powers conferred to ministers to make sure that to do a regulation so that the applicability and also the ease of implementation could be.
Looking at this report, it has highlighted salient points that talks about capacitizing the issues of regulations. And I believe it will not work further without those elements. One, if you look at the National Assembly and its functions and rules, looking at the scrutinization of some of these regulations, it needs resource base. Now, when the resources are not available, it becomes a burden. And looking at the experts in what we are to do in oversight functions and also taking the lead role in accountability, when and how soon do we work on some of those effects? I believe that we have a lot.
The committee's report was unanimously adopted, reflecting a commitment to ensuring effective governance while safeguarding the separation of powers within the Gambia's legislative framework. Maria Madem, reporting for Star TV News.